Obligations with subtopic nature and effect of obligations, and this is part 1. Just to give you an overview of what we are going to discuss, we have here the obligation to give and the obligation to do or not to do. So what can you recall? These are your prestation. Ano nga ba yung prestation? That is the object or the subject matter of obligation. Diba? Ang object or subject matter of obligation is one of the elements of obligation. So if we are going to classify obligation according to the nature of the performance, we have here the real obligation and the personal obligation. Your real obligation, that is your obligation to give, and your personal obligation, that is your obligation to do and obligation not to do. For your personal obligation, you can classify it further into positive personal obligation, and that is your obligation to do, and your negative personal obligation, and that is your obligation not to do. Third, we are going to talk about the breaches of obligations. There are two kinds of breaches, and that is your voluntary and involuntary. Example ng involuntary is the famous fortuitous event, and for your voluntary, that is your Article 1170. Yan yung mga fault, negligence, contravention of the tenor. So why is it important to know the difference? Because if it is voluntary, the debtor is liable for damages. Whereas if it is involuntary, the debtor is not liable for damages, but that is not absolute. Subject yan to certain rules. The last is we are going to discuss also the remedies available to the creditor in cases of breach. And there are two kinds of remedies that the creditor can avail, and that is the primary remedies. Example of that is your action for damages, action for performance, the action for recession. And next is your subsidiary remedies, and that is your action subrogatoria and action pauliana. Take note that in your obligation to give, there are three kinds of things that you can give, and that is your determinate or specific thing. Ano ba yung determinate? When the object is particularly designated or physically segregated from all others of the same class, that is your determinate or specific thing. Indeterminate or generic thing, when the object is designated merely by their class or genus. And last is your limited generic thing, when the generic objects are confined to a particular class. Example, if the obligation of the debtor is to deliver only a horse, the horse there is considered an indeterminate or generic thing. But if the obligation of the debtor is to deliver a horse out of his horse collection, then that becomes a limited generic thing. Why is it important to know if the thing involved is determinate or that is your specific thing, or indeterminate or your generic thing? Because nag-iiba ang rights ni creditor at nag-iiba din yung obligations ni debtor. So for your determinate or your specific obligation, the creditor can demand or can compel specific performance. So from the word itself, specific obligation, you can demand specific performance basis. Your basis is Article 1165. Anong sinasabi ng Article 1165? When what is to be delivered is a determinate thing, the creditor may compel the debtor to make the delivery. Correlate that also to Article 1244. Ano ang sinasabi ni Article 1244? The debtor of a thing cannot compel the creditor to receive a different one kahit yung binibigay niya is more valuable than that which is due. Second right of the creditor is he can recover damages for breach of the obligation. Diba sinabi dyan sa Article 1165 that in addition, or he has this right granted by him by Article 1170. So what is your Article 1170? Those who, in the performance of their obligations, are guilty of fraud, negligence, delay, or they contravene the tenor, they are liable for damages. So these are the rights of the creditor if the thing involved is determinate or specific. How about the obligations of debtor? Remember that we are still talking about determinate thing. So the debtor has the obligation to perform the obligation specifically. And your basis for that is Article 1244. The debtor of a thing cannot compel the creditor to receive a different one kahit yung binibigay niya is more valuable. Second, the debtor also has the obligation to take care of the thing with the proper diligence of a good father of a family. Your basis is your Article 1163. Every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family. Unless, so there is this unless. So, unless sinasabi ng batas na there is another standard of care, then yan ang masusunod. For example, for your banks and for your common carriers, the law requires that they exercise or they employ extraordinary diligence. Another exception is if the parties stipulated otherwise. In the absence of in the absence of law or stipulation of the parties, then you employ the proper diligence of a good father of a family. Third, the debtor has the obligation to deliver all accessions and accessories. Your basis is Article 1166. The obligation to give a determinate thing includes also the delivery of all its accessions and accessories, even though they may not have been mentioned. And last is the debtor is liable for damages in case of breach of the obligation. Diba sabi natin that there are two kinds of breach, and that is your voluntary and involuntary. If we are talking about determinate thing, take note na ang pinag-uusapan dito is voluntary breach, and that is your Article 1170. Those who, in the performance of their obligations, guilty of fraud, negligence, delay, or they contravene the tenor are liable for damages. Bakit? If the breach is involuntary, and that your involuntary is your fortuitous event, and that cause is the involuntary or your fortuitous, yun lang ang cause, wala nang iba. The fortuitous event was the cause why the debtor was not able to perform his obligation, and the thing involved is determinate, your debtor is not liable for damages. So what are the rights of the creditor if the thing involved is indeterminate or generic? So the creditor can ask for the performance of the obligation. Take note na it is only a performance, hindi specific performance. Kaya dyan, pag binabasa niyo yung mga reviewers or yung mga memory aids, sinasabi dyan is your substituted performance. Your basis of that is your Article 1246, when the obligation consists in the delivery of an indeterminate or generic thing, the creditor cannot demand a thing of superior quality, neither can the debtor deliver a thing of inferior quality. Second, the creditor can also ask that the obligation be complied with at the expense of the debtor. Your basis is Article 1165. If the thing is indeterminate or generic, he may ask that the obligation be complied with at the expense of the debtor. Your last is that the creditor can demand or can recover damages for breach of the obligation. And your basis is your Article 1170. How about the obligations of the debtor if the thing involved is indeterminate or generic? Here, the debtor has the obligation to deliver a thing which is neither of superior nor inferior quality. Your basis is your Article 1246. When the obligation consists in the delivery of an indeterminate or generic thing, the creditor cannot demand a thing of superior quality, Neither can the debtor deliver a thing of inferior quality. Second, the debtor is liable for damages in case of breach of the obligation. Sabi natin that there are two kinds of breach, and that is your voluntary and involuntary. Pag voluntary, pag ang involved is indeterminate or generic thing, si debtor is liable because of Article 1170. Those who are guilty of fraud, negligence, delay, or they contravene the tenor are liable for damages. How about if the breach is involuntary? That is the fortuitous event. And your fortuitous event is the only cause why the debtor was not able to perform the obligation. Sabi natin sa discussion natin, if the thing involved is determinate or specific, si debtor is not liable. How about if the thing involved is generic? Is the debtor still liable if it is due to a fortuitous event? The answer is yes. Your basis is Article 1263. In an obligation to deliver a generic thing, the loss or the destruction of anything of the same kind will not extinguish the obligation. So the obligation still subsists. Why is that? Because of the principle that the genus never perishes. So just to sum up what we have discussed, if the thing involved is indeterminate or specific thing, the obligations of the debtor are the following: to perform the obligation, specifically to take care of the thing with the proper diligence of a good father of a family, and recall your rule on the standard of care, and to deliver all accessions and accessories, and to pay damages in case of breach of the obligation. How about the rights of the creditor? He has the right to compel specific performance and to recover damages in cases of breach of the obligation. Take note that as regards damages, it does not apply if the reason alone is fortuitous event. For indeterminate or generic thing, the rights of the creditor are the following. He can ask for the performance of the obligation. Take note na ang sinasabi dito is your substituted performance. Second is he can ask that the obligation be complied with at the expense of the debtor, and he can recover damages for breach of the obligation. How about the obligations of the debtor? The debtor has the duty to deliver a thing which must be neither of superior nor inferior quality, and to pay damages in case of breach of the obligation. Take note again na ang sinasabi ditong breach applies not only to your voluntary breach but also to your involuntary breach, and that is your fortuitous event. The reason for that is because of the principle that the genus never perishes. 1984, number 14, bar question. Tingin agad sa tanong, has the obligation of Pedro been extinguished? Pedro here, he promised to deliver to Juan a Mercedes-Benz with plate number 123. So pag nabasa nyo yan, that is a specific thing because there is a particular description. It was particularly designated and it was physically segregated from other Mercedes-Benz. Also, there is this promise to deliver a Sony TV set, and that is a generic thing or indeterminate thing because it was designated only by their mere class or genus. Unfortunately, before the scheduled delivery date, both the Mercedes-Benz and the TV set which Pedro had intended to deliver to Juan were destroyed by an accidental fire. So has the obligation of Pedro been extinguished? Ano ang sinabi natin? If the reason is fortuitous event, the only reason is a fortuitous event. If the thing involved is determinate, then the obligation is extinguished. How about if the thing involved is indeterminate or generic? the obligation is not extinguished because of the principle that the genus never perishes. So that is the answer also of the UP Law Center. Take note of this, generic obligations are never extinguished by fortuitous events. 2008 bar exam question, diretso tingin sa tanong, who owns the movables inside the house? So Juliet here, she offered to sell her house and lot together with all the furniture and appliances to Delma. Before agreeing to purchase the property, si Delma gustong maniguro, so she went to the register of deeds to verify the title of Juliet. She discovered that while the property was registered in Juliet's name, it was mortgaged to Elaine. But she wants to buy the property badly, so she told Juliet to redeem the property from Elaine. So when the mortgage was released, Juliet executed a deed of absolute sale over the property and a new TCT was issued in Delma's name. Delma immediately took possession over the house and lot and the movables therein. Thereafter, Delma went to the assessor's office to get a new tax deck under her name. She was surprised to find out that the property was already declared for tax purposes in the name of XYZ Bank. So, sino sa XYZ Bank? XYZ Bank is the purchaser in the foreclosure sale of the property. So the question is, who owns the movables inside the house? If you take a look at the problem, para siyang LTD, nakakalito. But take note that here, the property first was registered in Juliet's name and a new TCT was issued and it was in Delma's name, but the tax deck was issued in the name of XYZ Bank. So yan yung nagpapalito dyan. And between, of course, recall your LTD, between a title and a tax declaration, ano ang mas matimbang? Siyempre, si title. But the question here is about the movables. It's about obligation. So, ano ang mga contractual obligations in a contract of sale? The debtor or the vendor here is obliged to deliver the thing as well as the accessions and accessories even though they may not have been mentioned. So here, Juliet, in this problem, that is not the case. Opposite pa nga, because si Juliet in this problem, she offered not only to sell her house and lot, but she also offered to sell her furniture and appliances. That is the reason why the owner of the movables is Delma. So this is also the answer of the UP Law Center. We're going to talk now about the fruits. The applicable article is Article 1164. So recall, your property, there are three kinds of fruits, and that is the natural, civil, and industrial. So the creditor has a right to the fruits of the thing from the time the obligation to deliver it arises. However, he shall acquire no real right over the fruits until the same has been delivered to him. So question, when does the obligation to deliver the thing and the fruits arise? Answer is depende, because if the source of the obligation is law, quasi-contracts, delicts, and quasi-delicts, the obligation to deliver arises from the time designated by the provisions of the Civil Code, or if there are special laws, the provisions in the special law creating or regulating them. How about if the obligation arises from contracts? Then the obligation to deliver the thing and the fruits arise as a general rule is from the moment of the perfection of the contract. Take note na magkaiba din ang perfection of the contract if the thing involved is a consensual contract, because recall your contract, sabi doon, if it is a consensual contract, it is perfected by mere consent. But if it is a real contract, such as your comodatum, your pledge, it is perfected upon delivery. What is the basis? Your basis is Article 1537. The vendor is bound to deliver the thing sold and all accessions and accessories upon the perfection of the contract. Also, the vendor shall deliver the fruits from the day on which the contract was perfected. But is this rule absolute? Hindi, kasi the parties can agree that the delivery of the thing and the fruits will happen at a different period or at a different time. We said that the creditor has a right to the thing as well as to the fruits from the time the obligation to deliver arises. But what is the nature? What is the nature of such rights? So before delivery, the creditor has a personal right. But after delivery, that right is converted into a real right. So what is the difference between the two? If it is a personal right, it only establishes a legal relationship between two persons. Pag pinag-uusapan mo sa real right, that establishes a legal relationship not between two persons but between the thing or the property and a person. Second, pag personal right, you can only enforce that against the other party to your contract. So if the contract is between A and B, you can only enforce it against B. But if it is a real right, that is considered by law as an absolute right. Therefore, you can enforce it against anyone, even if that person is not a party to the contract. So this is the reason why if it is a personal right, si creditor, ang kanyang karapatan lang is to ask the debtor for the delivery of the thing and the fruits thereof. Whereas after delivery, si creditor now has a right over the thing, and that right can be enforced against anyone, against the whole world. So for application, let's take a look at this 1986 bar question. Number 11, Mr. Nagbibili, he sold his mango plantation to a bentorero effective immediately. Nakakalito yung names, pero there is a purpose for that, and the purpose is mas lalo kayong malito. The document stipulated, however, that the delivery would be effected 6 months from the execution of the deed of sale. When the said period arrived, a bentorero demanded delivery in writing but Nagbibili dilidalid. It was not until a month afterwards that Nagbibili finally gave the land to a bentorero. In the 3 weeks before the delivery, maloko talaga tong si Nagbibili, he sold and delivered the entire produce of the mango plantation to Mr. Comerciante, another person. Comerciante knew nothing of the contract between Nagbibili and a bentorero. A bentorero now seeks to recover from Comerciante either the full value of the mangoes or a similar amount and quality of the mangoes sold. So thus, a bentorero have this right against Comerciante. So let's apply what we have discussed. Sabi natin, ano ang contractual obligations in this contract of sale? Si debtor has the obligation to deliver the mango plantation, the thing itself, as well as its accessions, accessories, and the fruits. Kailan niya i-deliver yon? Sabi dyan is from the moment of the perfection of the contract. So since this is a consensual contract, this is perfected by it was perfected by mere consent. But that rule is not absolute because the parties can agree to a different period or to a different time. So yun nga ang ginawa nila dito, that the delivery would be effected 6 months from the execution of the deed of sale. Pero 3 weeks before the delivery, ang ginawa ni Nagbibili, 3 weeks before the delivery, Nagbibili sold the entire produce of the mango plantation to another person, and that is Comerciante. So here, there is no delivery yet. Before delivery, the creditor has only a personal right. Ano ang sabi natin? If it is a personal right, personal right, it only establishes a legal relationship between nagbibili and abenturero. Therefore, if it is a personal right, he can only enforce it against the other party to the contract. In this case, abenturero can only enforce it against Mr. Nagbibili. If it is a real right, and that happens if there is now a delivery, that is the only time that Mr. Abenturero can enforce it against Mr. Comerciante. So this is the answer also of the UP Law Center. Let me end this video through this 2012 MCQ. The creditor has the right to the fruits of the thing from the time the thing is delivered. The obligation to deliver the thing arises. The contract is perfected or the fruits are delivered. So by this time, dapat alam niyo na yung sagot, and the sagot is letter B. The obligation to deliver the thing arises. So thank you very much for watching and have a good day.